Hello, everybody. Happy Sunday. Hope your weekend has been going well. The superb owl kicks off a few hours from now. However, in the meantime, history by mail. I know we didn't actually have one in January because this is the January one, and I got it on January, I think, the 30th or the 31st. So we might get lucky and actually have two history by mails this month, but we will see. And also starting a new unit. The last one's the transfer of power unit, but let us see what in the whoa. United States of America, President of the United States of America, whereas the Circuit Court of the United, okay, so it's a court something, and you can kind of see the outline of what would have been maybe some sort of stamp on the original document. Appears, said, what? Okay, so it's President of the United States of America, Honorable John Marshall, Chief Justice of the said Supreme Court. Okay, so we're going way, way, way back. Okay, that told me not much. But we do have a transcript. Oh, it's a long transcript. Settle in. We have the transcript of the notice of the Supreme Court's decision in Worcester versus Georgia, January 9th, 1832. I am unfamiliar with what case that was. The United States of America, SS, the President of the United States of America, the Honorable Judge crossed out of the Superior Court. Oh, it's okay, so it's a full transcript including everything. That Samuel A. Worcester, defendant for indictment for residing in the Cherokee Nation without a license. The judgment of the said Superior Court crossed out. Okay. All right, well, let's get a little background information on just what in the world this is. That's going to provide us a lot more. And then, actually, you know what? Here, just in case anybody would like to read it, I will put up the transcript, because there's a lot of interesting stuff on the document that looks like it was crossed out, but there we have it in case you would like to pause and read that. But now we're going to get into the notice of the Supreme Court's decision in Worcester versus Georgia, January 9th, 1832. The enclosed documents were sent by the U.S. Supreme Court to the Gwinnett County Superior Court in Georgia, reporting that the decision in Worcester versus Georgia had been overturned. Okay, interesting so far. Worcester versus Georgia was a landmark case which began the process of establishing Native American tribal sovereignty in America by defining the relationship between Native American tribes and the state and federal governments. Okay. Each notice refers to the defendants Samuel Worcester and Elijah Butler. Samuel Worcester. Samuel Austin Worcester was born in Vermont in 1798 and became a congregational minister. In 1825, he was sent by the American Board of Commissioners of Foreign Missions, ABCFM, okay, that's much easier, to missionize Cherokee Native Americans in the American Southwest. Elias, a young Cherokee whose native name was Uwati, I apologize if I mispronounce anything in the Cherokee language, had been educated in New England schools and was the nephew of a wealthy Cherokee National Council member. Elias asked Samuel to use his experience with printing missionizing material to establish a Cherokee newspaper. Interesting. A few years earlier, a Cherokee named Sequoia had developed the first syllabary, not familiar with that one, or set of written characters to represent the Cherokee language. Cherokee people were impressed with the European American papers, which they called talking leaves. Elias thought a newspaper could help raise Cherokee literacy and unify the Cherokee nation. Worcester secured financing to build a printing office and made a metal type for each of the 86 new Cherokee characters. 86 characters. I have never actually seen the alphabet. The first edition of the Cherokee Phoenix was printed on February 21st, 1828. Worcester was honored with the Cherokee name Atsinutsi Nutsi, meaning messenger. Again, apologies if I badly mispronounced that. Cherokee Nation versus Georgia. Samuel Worcester, with the support of his sponsor, the ABC-FM, wanted to fight the... Sorry, I'm a little off-center there. Wanted to fight the encroachment of European Americans on settlers on native lands. They devised a plan to use the courts to establish the Cherokee Nation sovereignty and planned to take their case to the U.S. Supreme Court. In 1828, Georgia passed a series of acts stripping Cherokee residents of their rights and removing them from land the state wanted. The Cherokee Nation asserted Georgia did not have the authority to take their land or rights since the nation was sovereign and protected under a treaty with the U.S. federal government. After failed negotiations with President Andrew Jackson, well, sadly that's not a surprise with him, the Cherokee Nation sought an injunction from the U.S. Supreme Court to prevent Georgia's actions. The Cherokee Nation hired William Wirt, former U.S. Attorney General in the Monroe and Adams administrations, to defend them in the 1831 case Cherokee Nation versus Georgia. The Supreme Court refused to hear the case, arguing that an Indian nation is not a foreign nation for purposes of jurisdiction under the U.S. Constitution, but rather a domestic dependent nation. Since its inception, the U.S. government has negotiated treaties with Native Americans in the manner of negotiations with foreign governments. Oh, interesting. The ruling in Cherokee Nation versus Georgia changed the status of Native American tribes from independent sovereign nations to domestic dependent nations. However, treaties were still being negotiated between the U.S. government and tribal governments and needed congressional ratification to take effect. Worcester versus Georgia. The issue of tribal sovereignty arose again the following year. Samuel Worcester and 11 other missionaries published a resolution protesting an 1830 Georgia law barring all white men from living on Native American land without a state license. Worcester argued that while the Georgia law may not have been intended to restrict white settlement on Cherokee land, it meant that the Cherokee Nation did not have the ability to manage its own territory. Georgia Governor George Gilmer, that's a lot of G's, ordered a militia to arrest Worcester and the other missionaries. They were tried, convicted, and sentenced to 4 years of hard labor at a Georgia state penitentiary by a grand jury for, quote, residing within the limits of the Cherokee Nation without a license, end quote. While they had obtained permission to live on Cherokee land from both the Cherokee Nation and the U.S. government, they had not obtained a license from the state of Georgia. All the missionaries accepted pardons except Samuel Worcester and Elizur Butler, who intended the case to rise to the Supreme Court. The novel question raised was whether the state of Georgia had jurisdiction over Worcester and Butler, since the missionaries were living in a territory under federal authority with the permission of the federal government and the Cherokee Nation. William Wirt again defended the Cherokee Nation in the Supreme Court. Now, this is getting interesting. In 1832, the Supreme Court had 7 justices. The Supreme Court originally began with 6, as had been specified by the first U.S. Congress in 1789. The number of justices then changed several times until 1869, when the current total of 9 was settled. The Supreme Court ruled 5-1 in favor of Worcester and Butler, with Justice William Johnson absent due to illness and Justice Henry Baldwin dissenting. The court ruled that the Cherokee Nation was an independent nation and therefore only the federal government and not state governments had the authority to deal with Indian nations. The court held that Georgia statutes prohibiting non-Native Americans from living on Native American lands without a license was therefore unconstitutional. The convictions of Worcester and Butler were also vacated, and the court ruled that the defense of their indictment, arrest, and imprisonment ought to have been allowed and admitted. Despite the ruling, Governor Gilmer continued to hold Worcester and Butler in prison, where they remained until the following year when a new Georgia governor was elected. Worcester and Butler were pardoned with the condition they would cease to missionize the Cherokees in Georgia. And then, yes, the Trail of Tears. It unfortunately goes downhill from there. President Jackson refused to uphold the Supreme Court's decision in Worcester versus Georgia since he feared warfare between Georgia state militia and federal troops. Henry Clay, John Quincy Adams, and Ralph Waldo Emerson, well, that's an interesting trio of people, were among Jackson's harshest critics in ignoring the decision. Instead, in 1835, Jackson negotiated the Treaty of New Echota, I think, with the Cherokees. This treaty gave the tribe 2 years to vacate their land east of the Mississippi River in exchange for territory further west and a $5 million federal payout. Over 16,000 Cherokees signed a petition against the treaty, and only a small portion of the tribe left voluntarily. Federal and state troops forced the remaining Cherokees to move in 1838, enduring freezing temperatures. The term Trail of Tears comes from the Cherokee description of the forced relocations. Nunahi do not tlo hailu e I? I really am not sure. Meaning the trail where they cried. Several thousand of the relocated Cherokees perished en route in addition to thousands more from other tribes. Not all Native Americans left peacefully. Some resisted. Many Seminoles in Florida, for example, fought against the U.S. troops for decades. Samuel Worcester and his wife moved to Oklahoma in 1836 to continue missionizing Cherokees. Samuel translated the Bible and hymns into Cherokee and continued publishing a Cherokee newspaper. Worcester versus Georgia is the last of the Marshall Trilogy, a set of 3 Supreme Court decisions named after Chief Justice John Marshall between 1823 and 1832, which established the legal and political standing of Native American nations in American law. In 1823, Johnson versus Mantosh, that's odd, ruled that private citizens could not purchase land from Native Americans. In 1831, Cherokee Nation versus Georgia ruled that the relationship between the Cherokee Nation and the federal government is like a ward to its guardian. Finally, in 1832, Worcester versus Georgia is historically important for establishing the principle of tribal sovereignty by ruling that states could not diminish the rights of tribes, which held distinct sovereign powers granted by the federal government. This is the first of the 4 documents, in the Native American series. To learn more about that, there is your URL right there. That was just utterly, utterly fascinating. I'm having all sorts of camera issues today, so I apologize. But, and the best part about this, once again, is something I did not know much about. When I pulled up the transcript, Worcester versus Georgia, I did not immediately recognize the name of the case. But this was quite interesting. And then the one thing I wanted to make note of, and it said here, the many Seminoles in Florida fought against the troops. I think I want to say it was until very recently, or something that I believe that the Seminole tribe had never officially surrendered to the U.S., so technically they were still, I don't know, it's something like that. Don't quote me on that. I'm going to have to look into that. But again, as soon as I saw, the Trail of Tears, that is sadly another of the darker portions in American history. But again, history is, I've said it before, history ain't pretty, but history is 1, fascinating, and 2, important, because without it, a lot of these things would sadly be forgotten, and we need to remember all that happened before us to preserve the memory and continue down, hopefully, the right path. So that is going to do it. Please enjoy the football game later on today. It is what it is. I'm not that thrilled. I'm not that, jumping with excitement to see the Super Bowl, but, it is what it is. But we will go from there. So thank you so much to everybody watching. Hopefully you enjoyed it. We will see you tomorrow.